Hello and welcome to Topic 4, Lecture 1. And in this lecture, we're going to be talking about civil liberties. So, what are we going to be covering in this lecture? Well, first, we're going to define some key terms that are important for understanding the chapter that we're doing this week and also understanding the chapter that we're going to be doing next week. And so, we're going to define the key terms civil liberties and civil rights. Then in this lecture, we're going to have a brief history of the Bill of Rights, and we're going to talk about the way the Bill of Rights was nationalized to the states. And so that's what we've got on the docket. Let's go ahead and get started. So, Chapter 4 is dedicated to learning about civil liberties. So, what exactly are civil liberties? Well, civil liberties are your individual rights. They're the individual rights and personal freedoms with which governments are constrained from interfering. And so when we talk about civil liberties, we're talking about the freedom, and liberty is a word that means to be free, right? That it's the freedom of speech. It's the freedom that you have to remain silent if you're being questioned during a criminal a trial, but the right to remain silent extends beyond that. It's the right to be free from unreasonable search and seizure. It's the right to exercise your religion or to not exercise religion. You're going to be learning about all of these different kinds of personal freedoms that we have in the United States. And we find these liberties, these civil liberties, in the Constitution. They're the first 10 amendments of the Constitution. And so this chapter is really dedicated to giving a detailed sort of walkthrough of all of these different liberties. Now, keep in mind, one of the things I tell my students is to think about civil liberties as the things that government cannot do. I often tell students that it's the thou shall not, okay? It's telling government that it cannot interfere with people's speech. It cannot disrupt the free press. It cannot take away people's rights to a fair and impartial jury, okay? And so really the Bill of Rights is, its focus is the government. It's telling government that you can't do these things, that you can't interfere with these freedoms that are granted to the people within the country. Now, the chapter that we're going to be doing next week, Chapter 5, is not focused on civil liberties, but it's focused on civil rights. So what are the differences between civil liberties and civil rights? Well, the big difference is civil rights is telling government it must do things, okay? And so as the definition from your textbook says there, is that civil rights are obligations imposed on government to guarantee equal treatment and to protect citizens from discrimination. As you'll be learning next week, that in the Constitution, in the 14th Amendment, it says that no states shall deprive people of the equal protection of the law. In other words, that everybody needs to be treated equally and that the government is responsible for making sure that that equal treatment and that non-discrimination actually takes place. And so civil rights is really more proactive. It's basically, as we're going to be learning next week about in the civil rights movement, it's where people throughout the United States history have seen laws passed that are discriminating on the basis of race, the basis of sex, the basis of, body ability, the basis of religion, the basis of ethnicity, age, etc. And they're basically saying that you're treating me, the government's laws are treating me, a person of color, or me, a woman, differently than you are treating a person who is white or a man, okay? And so that's what civil rights are, these demands that we place on government. And that it's the request, and not just the request, but it's the obligation that the government has to act and govern in an impartial manner. And the civil rights are embedded in the 14th Amendment with the Equal Protection Clause, learning about that next week, but also in two key pieces of legislation the Civil Rights Act of 1964, the Voting Rights Act of 1965, and then I have Title IX there too, because that deals with equality in education as it relates to gender, okay? So those are the big differences between civil rights and civil liberties. Now, there are times when civil liberties can come into conflict with civil rights, okay? In other words, there are times when an individual or a group is exercising their personal or their group freedoms, right? Their liberty, their freedom of speech, their freedom of press, their freedom of assembly, whatever it may be, their religious, exercising their religious beliefs. That in the exercise of those personal liberties, it can result in discrimination, discriminating against, African Americans, discriminating on the basis of race, discriminating against women or men, discriminating on the basis of like religion, discriminating on the basis of a person's sexual orientation. So I want you to sort of take a moment here, maybe to click off the video and just see if you can think of some examples of when civil liberties and civil rights come into conflict with each other. So here are two good examples of where civil liberties and civil rights come into conflict with each other. And the first one we're going to talk about is the, which you've probably heard about this case, and there was recently a similar case that was heard by the Supreme Court. But this, the Masterpiece Cake Shop case is a good example of where someone's religious beliefs comes into conflict with laws that are on the books that are anti-discrimination laws. So the backstory on this case is Jack Phillips, he owns this bakery, and that he makes all different sorts of cakes, okay, including wedding cakes. And because of his religious beliefs, he does not want to make a wedding cake for a same-sex marriage wedding. It's not that he's not willing to serve his gay and lesbian customers in his shop. He'll make them brownies, any other kinds of cakes he'll make. But he feels like he can't make a wedding cake for a same-sex marriage because it goes against his religious beliefs. On the flip side of that, though, Colorado has these laws on the book that makes it, it's against the law to discriminate against customers. If you own a shop that's open to the public, that you must not discriminate against people on the basis of their sex, race, religion, and sexual orientation. And so Jack Phillips got in trouble because he violated the anti-discrimination law. The case did go to the Supreme Court. The decision was, we still don't really know the decision about whether or not a bakery owner can deny a lesbian or gay couple a cake, although a ruling this summer about a website sort of indicates that a person's religious freedoms can kind of prevail or supersede the anti-discrimination laws. But it's a really good example of when you're exercising your personal freedoms comes into conflict with a person's civil rights, the obligation that government has to treat people equally. Another example is the Unite the Right rally that took place in Charlottesville, Virginia in 2017. This was a neo-Nazi and white supremacist rally. These folks were angry because, as you may recall, there was this horrific shooting in Charleston in 2015 where an individual came to a church and shot 9 black members of the church. And so in response to that, cities throughout the United States began, particularly in the South, began to take down Confederate monuments. And they started doing that in Charlottesville, Virginia. And the neo-Nazis and the white supremacists were mad as hell, and they weren't going to take it anymore. And so you might remember this. This got a lot of news coverage, but I know a lot of you are also kind of on the younger side, so you may not remember it. But these groups marched for 2 days, chanting racist slurs and, Jewish slurs. They said Jews will not replace us because they're worried about the great replacement theory, right? And so they were exercising their their freedom to assemble and to speak, but on the same token that they were creating an incredibly hostile and ultimately deadly environment that particularly targeted African Americans and Jewish folks. Basically their speech was potentially impinging upon their right to be treated equally and to not live in a discriminatory environment. And so those are just two of the examples of where civil liberties and civil rights come into conflict with each other. Okay, so let's just give and talk a little bit about the brief history of the Bill of Rights. So as we know, the Bill of Rights is the first 10 amendments to the United States Constitution. And you might be wondering, well, okay, why is the Bill of Rights, why are those amendments to the Constitution? Why isn't the Bill of Rights a part of the actual body or the articles of the Constitution? And the reason for that, so in other words, why are they amendments? Well, the reason for that is because the folks at the Constitutional Convention, or at least the majority of the people at the Constitutional Convention, did not think that a Bill of Rights was necessary. That basically Alexander Hamilton, one of the authors of the Federalist Papers, James Madison, Alexander Hamilton, and John Jay, they wrote the Federalist Papers. Those were the essays that were in newspapers throughout the United States, trying to make a case for why the Constitution should be ratified. But basically, what Alexander Hamilton said is, why do we need a Bill of Rights telling government what it can't do when there's nothing in the Constitution that gives the federal government the right to do that, right? And so as it says there, for why declare that things shall not be done, which there is no power to do. So remember, in last week, we talked about the express powers of the federal government, the powers that are enumerated in the Constitution, right? Hamilton's saying, there's nothing in the Constitution that gives Congress the power to establish a religion or to take away your freedom of speech or, trample upon the rights of the criminally accused. Congress doesn't have that power. And so they didn't think that a Bill of Rights was necessary. However, in order to get, the Constitution enforced, that it needed to be ratified by the states. And so the Constitution went state by state to the state conventions where they were ratifying the Constitution. And states presented with the Constitution realized that, we are not going to sign, we're not going to ratify this Constitution without a guarantee that there's going to be a Bill of Rights added to it. Because you say, Federalists, that Congress isn't going to do these things. But unless it's actually written down as a thou shalt not do, then Congress is likely to engage in those acts, maybe by saying through their implied powers or the elastic clause, okay? And so a deal was struck. In order to get the Constitution ratified, the Federalists agreed to say the first act of Congress is going to be the crafting of the Bill of Rights. And it was written by James Madison in 1789. He talked about it as being a nauseous project, a project that made him want to throw up. And the reason was because, he, was writing these liberties, right? Sort of saying, these are your personal freedoms. These are the things that government can't interfere with. And he was really worried about, what if we leave something out? What should be included? What shouldn't be included, okay? And so he found it to be a very challenging project. The Bill of Rights was ultimately passed by Congress and then ratified by the states on December 15th, 1791, which is in fact my birthday. I was born on December 15th. And I actually was born on December 15th, 1791, because whether you know it or not, I'm a vampire, right? Although it looks like I'm taping this during the day, so maybe I'm not a vampire, but you'll never really know. All right, so this brings us to the third topic that we're going to be discussing in this lecture, and it's the topic of nationalizing the Bill of Rights. That is the question about whether the Bill of Rights applies only to Congress, the federal government, or whether the Bill of Rights applies to the actions of the states as well. Okay. Now, I have up there on the screen the First Amendment, okay? And it reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. That's the First Amendment. It's got 5 liberties in it, okay? Now, back in the day when I was wild, youngin', wanting to not be told I can't do this and can't do that, right? I was all about the First Amendment, right? I mean, I was going to exercise my liberties as much as I wanted to. And in fact, I went to a conference hosted by the ACLU, the American Civil Liberties Union, and they were handing out these stickers that had the First Amendment on it, just like that. So I got a couple of those stickers, and I put one on my VCR at home on top of my TV. You might remember VCRs from such things as a million years ago, but it was a machine that you put a tape in. You could watch a movie on a video cassette. And I put it on there to remind myself that people can make movies and freely express themselves, right? And so they can make violent movies, they can make funny body movies, they can make pornography, right? And as long as the Supreme Court said that those expressions are protected by the First Amendment, then they're free to make those and I'm free to watch those, okay? And so giddy up, right? I was just like a full plethora of whatever I wanted to watch. But then one day, and I lived in Indiana at this time, okay, which is a pretty conservative state, and so I was, looking at that sticker as I was about to put in some sort of contraband to watch. And, not contraband, but some free expression to watch. And then I saw that word Congress. And I was like, wait a second. Congress shall make no law. But what about states? I live in Indiana. Can Indiana make a law abridging a person's free expression, right? Can they make a law saying that you can't watch these expressions, that are in movies? And so it made me wonder, wait a second, does the First Amendment actually apply to the states? And so this question that I had as a youngin about, whether or not the Bill of Rights applies to the state, whether that is not a question that was unique to me. That was a question that arose in the United States soon after the Bill of Rights was ratified. And so when we're talking about nationalizing the Bill of Rights, we're asking ourselves, does the Bill of Rights apply only to the federal government or to the states as well? And really, when you look at the Bill of Rights and it has that word Congress, it's sort of like, well, the intent is that the Bill of Rights applies to the Congress, the federal government, not to the actions of the state. And in fact, in a landmark case that came before the Supreme Court in 1833 called Barron versus Baltimore, that question about whether the Bill of Rights applies to the state came to the court in that case. And in Barron, they said, you know what? The Bill of Rights does not apply to the states. The Bill of Rights only applies to the actions of the federal government. If states want to have their own Bill of Rights, go for it. But the Bill of Rights that's in the U.S. Constitution only applies to the actions of the state. Now, Barron versus Baltimore is a great case. This is a case that John Barron, he lives in Baltimore, and he owns a ship wharf, right? Like where ships can come and dock at his wharf. He had a great wharf. It was really deep. It was like the premier wharf in Baltimore. He got tons of business. But then in the 1830s, Baltimore's like, we're going to renovate. We're going to make our town a lot better. We're going to make streets and cobblestone streets and just make it like more new, more modern for that time period. And so what Baltimore did was that they basically shoveled up all this gravel and they put it in the port, right? They put it in the water where these ships were docking. And unfortunately for John Barron, he had the best shipping dock area. But then after the improvements that Baltimore made with all this silt and gravel that went into the harbor, his business was destroyed. Ships could not come and dock there anymore because it was too shallow. And so he was looking for a remedy. He was looking for he felt like he was harmed, and in fact he was. And so he was wanting that harm to be remedied. And so he turned to the Supreme Court. And basically what he said was that in the Fifth Amendment, there's this part in the Fifth Amendment called the Takings Clause. And what the Takings Clause in the Fifth Amendment says that government can't take away your property without a fair compensation, right? That if they're going to take away their property, they've got to give you money of the fair value of the property that they took from you. And so John Barron, smart, went to the Supreme Court with his lawyers, of course, and he said, look, the Fifth Amendment prohibits Baltimore from taking away my property without giving me recompense for it. And what the Supreme Court under John Marshall said was, nope, you're wrong. That the Bill of Rights does not apply to the actions of the state of Maryland or the city of Baltimore. It only applies to the federal government. So if the federal government came in there and messed up your wharf, then you have a case. But you don't at this point. And so from the ratification of the Bill of Rights until 1868, the Bill of Rights only applied to the federal government. That changes with the inclusion of the 14th Amendment into the United States Constitution. In the 14th Amendment, what the 14th Amendment says is that it says that no state can take away your life, liberty, or property without the due process of law. The idea of the 14th Amendment was to prohibit states from taking away newly freed enslaved people's rights, their property, their liberty. And so it was telling states what they can't do. And so that due process clause, telling states that you can't take away your life, liberty, or property without the due process of law, that clause was used to incorporate the Bill of Rights to the states. And so that avenue to incorporate the Bill of Rights to state actions started in 1868. Now, one of the things I want you to keep in mind about the nationalization or the incorporation of the Bill of Rights to the states is that it didn't happen all at once. It could have, but it didn't. And so what that means is that with the inclusion of the due process clause in the 14th Amendment, the Supreme Court could have waved its magic wand and said, because of the due process clause, all of the Bill of Rights applies to the states, but that is not how it worked. And in fact, some parts of the Bill of Rights, very few, are still not incorporated to the states. And so let me put my magic pen on here. So what you should keep in mind is that the Bill of Rights was selectively incorporated. And it was incorporated because people demanded that provisions of the Bill of Rights, those liberties, apply to the states. And so starting in 1897, that was the first case that was incorporated to the states, and it was about eminent domain, the takings clause, just like John Barron, that then the Supreme Court said, yep, the Fifth Amendment applies to the states. But then it basically went case by case and liberty by liberty, okay? Freedom of speech, 1925, Gitlow. Freedom of assembly, DeJong, 1937, okay? And so it really took a very long time. The rights of the criminally accused weren't incorporated to the states until the 1960s during the Warren Court. And so while the federal government needed a warrant in order to search your house, states did not, unless it was in their laws, they didn't need a warrant to search your house. If you don't believe me, just ask Delorey's map from Map v. Ohio. And so here it's this graph is a little bit outdated because it says that the last liberty that was incorporated to the states was the right to bear arms, the Second Amendment in McDonald versus Chicago in 2010. But in 2019, an additional provision of the Eighth Amendment, the excessive fines provision of the Eighth Amendment, was incorporated to the states in 2019. So there's a couple of takeaways here, what I want you to keep in mind. One is that real people felt like their liberties were violated and that they took it to the courts and said, does this liberty apply to the actions of the state, right? And so it took real people, real controversies, real cases to make the Bill of Rights incorporated. And also, I mean, it's just interesting to see that for a long period of our time, there was a lot of differences and not necessarily good differences. In some states, hey, you were protected by a warrant. In other states, you weren't until it was incorporated by the Supreme Court. So in conclusion, I just want you to think critically about incorporation. One of the things I want you to think about is, should all provisions of the Bill of Rights, should they have all applied to the states at once? Total incorporation. Why do you think the Supreme Court decided to not do it that way, but instead to do it selectively, case by case, liberty by liberty? Are there advantages to selective incorporation, right? Are there advantages to having each liberty come to the court and ask whether or not it applies to the state? Or are there some disadvantages to that? Another thing to think about is, what if the Bill of Rights only applied to federal actions, not states? Today, what if the Bill of Rights had never been incorporated? Because they could have easily said, well, the due process clause, that can't be used to incorporate the Bill of Rights to the states. The Supreme Court could have easily said that. They're sort of saying similar things about the due process clause right now as it relates to personal freedoms. So that would have set up where you had one Charter of Liberties that told Congress what it can't do, and another Charter of Liberties telling your state what it can't do. But there would be lots of differences among the states, right? Some states could have a really robust Bill of Rights, other states maybe not so much. And so what do you think about that? Would that be a good thing for us to have more robust protections at the state level? Or is there an advantage to having the federal Bill of Rights applied to the states? And maybe think about what some of the impacts on democracy that might be. Are people better served by by incorporating the Bill of Rights from the U.S. Constitution to the states, or might they be better served if we had our own state level Bill of Rights? Just something to think about. That's it for me. Thanks for listening. I will talk to you again soon.